This is how the justice system works in the real world. It's not what they showed us in Depp versus Heard. I was in the Provincial Court of British Columbia before the Honourable Judge C. Sukkot on the cusp, BC, July 14, 2022, in the matter of the Family Law Act, Sarah Rainford and Trevor Holsworth. It was with FMEP prosecutor Tina Williams. They're trying to collect child support documents or something like this. But this is what she says. If the debtor is before the court and the court finds that the debtor is capable of complying with the order the debtor to be imprisoned for a term of not longer than 30 days. So my position would be that Mr. Holsworth is currently required to pay $2,502 per month child support for the 2 children pursuant to the Supreme Court order. Then, based on the fact that he hasn't proven otherwise, he is in a position to pay a payment, over and above that toward the arrears of support. You can find that Mr. Holsworth is capable of complying with the disclosure order, but just has decided that he's not going to, and incarcerate Mr. Holsworth for a period of up to 30 days. If Mr. Holsworth had any appetite to change the order, certainly the director would wait until that application came before the court, but it doesn't appear that that's going to happen. So I responded, I just wanted to bring up the idea of recusal. There's 2 matters that I can think of that might come into that. In our previous hearings, I brought up issues that are going to come up here again. 1, the problem with the Minister of Justice and the Attorney General not complying with the Charter, and which you ignored in a previous trial, which is conduct that I'm alleging that the FMEP is also in breach of. I've been communicating with the FMEP through Tina, through their caseworker, through Chris Beresford, and through the Provincial Attorney General, David Eby. And they are all aware of the facts in this matter. However, no argument has been presented to dispute the facts that I present. 2. In my previous experience with FMEP, when confronted with fraud by lawyers, their decision was to delay collection of child support for 5 years, which was the same decision that you came to when you heard my matter about the income tax issue. I made the same sort of arguments about failures in the rule of law at that time, and your decision was to delay collection activities for 5 years, rather than addressing. The court interrupts. Oh, I see. Are you suggesting that I recuse myself because of a perception of bias from yourself with respect to my ability to hear this? And Crown Counsel Tina Williams responds, Your Honor, I don't understand that just for the simple fact that this hearing has nothing to do with any of the constitutional arguments. It's very narrow. The court continues, I'm not going to grant your application that I recuse myself. I frankly didn't follow it particularly clearly. I agree with Ms. Williams. This is a very narrow proceeding under the Family Maintenance Enforcement Act. And I go, I'm talking about the problems of the administration of justice not being in compliance with the law. The court continues, Justice Leister, I presume. I'm not privy to what happened there, but I presume she heard your arguments as well and did not give credence to them. And I respond, no, she just refused to rule. She refused to even address the issue. I made a request for a writ of mandamus. She refused to act judicially. She refused to say yes or no, and she has refused to provide written reasons for her decisions. So it appears that Crown Counsel is aware of the arguments that I presented. Chris Beresford and the Attorney General of BC and the Attorney General of Canada are all aware of the arguments that I've made. There's been a constitutional question presented to the court regarding the constitutionality of the Attorney General failing to respond to the enforcement procedures of the Charter. Not one single argument has been presented against it. In trial, with you, Crown Counsel said no comment. So that's a problem. I'm going to be alleging an abuse of prosecutorial discretion and requesting the court examine that as a possibility here. So going back to the previous disclosure, when I reported fraud by lawyers, including failing to comply with court orders regarding trust account statements, altering and removal of court documents to conceal those facts from the court, resulted in no referral to Crown Prosecution or the RCMP, but FMEP granted me a 5-year delay before they started collection activities. So they admitted that there was a problem. That's why they gave a 5-year delay on the collection, but there was nothing else done. That is a problem for the rule of law. I have been in contact with the Prime Minister's office, and they forwarded it back to the Minister of Justice, who gave false and misleading statements back to me. He said he had no duty, which, as you know, is incorrect. The Prime Minister's office, who forwarded the issue back to the Minister of Public Safety, who has not responded to me at all. The reason why this case is here is my ex, the mother of my children, is attempting to abuse the powers of the state to subjugate and extort me due to a perception of vulnerability, as the Canadian Judicial Council claim that a woman's word was of more weight than my evidence as a man with the transcript, which I used legitimately to check a lawyer who created a fraudulent court order. The separation agreement specifies a requirement for mediation in multiple places in that document. She did take it to mediation, but she mediated that the equalization payment in the separation agreement included debts plus equalization payments. Effectively, she was asking for twice as much. And that's what we mediated upon. There was nothing for me to mediate on because it was obviously bad faith mediation. The mediation failed. She took it to court in Kelowna, and none of the items that were in the mediation, none of that was brought to court. She did not bring to court the idea the equalization payment being a debt plus equalization payment. She brought up the matters of increasing my child support, and she brought up matters of taking custody from me. She got primary care of the children, and she increased my child support payments from $200 to $2,800. I was not served, so there's a problem with abuse of the powers of the state. The separation agreement that is filed with the court is a fraudulent one. I have 2 copies of it here. The one that she's filed with the court has Greg Stacey, a lawyer in Nelson, who was the lawyer that did not comply with the court order to have the trust account statements presented to the Law Society, and the Law Society subsequently not providing those to me after they completed an investigation on the matter. I communicated the problems that I've disclosed to this court to both lawyers. I communicated the problem to my ex's lawyer, and I also hired a lawyer, and I communicated the problems to him. My lawyer refused to represent me as to the best of his abilities based on the facts of my case, and I offered to mediate with her lawyer on the outstanding issues. Got it in writing. She refused to mediate. She did not mediate prior to bringing it to court, which I believe is a problem for her as far as conduct with her Law Society. If I'm going to trust the court with the best interests of my children, then the conduct of its officers and lawyers need a great deal of upgrading. There's a very large difference between trust and being coerced to accept the decision of a court. I'm here trying to get justice. I'm trying to do everything in my powers to do that in a reasonable manner according to the law. Crown here is saying, we want to audit you. Here's the last audit that I had with the Crown from the CRA. I presented a lawyer's trust account statement on a purchase of a property detailing GST paid to the lawyer's trust account for the purchase of a property. The CRA comes back to me, as I read into court. Based on the information currently available, it is our view that the assessment of $15,900 in respect to the acquisition of taxable real property is correct. However, should the partnership receive evidence in the form of a cancelled check showing its payment of the $15,900 to the Receiver General of Canada for the tax payable, we would then be able to trace the payment and ensure it is credited to the partnership account. But I paid it to the lawyer's trust account. But Crown wouldn't accept that as sufficient evidence. The Law Society audited the trust account statements of lawyer Greg Stacey, but they refused to provide the results to me, and ultimately did not punish either lawyer, even though Greg Stacey wrote a letter admitting he failed to respond to a court order and begged for mercy. I requested written reasons from the Law Society and was refused. I went to the Ombudsman, and they gave up after a year. What the Law Society did was remove all the evidence that implicated the lawyer. They wrote a letter showing the evidence that they did present. They didn't present it to the Discipline Committee. They presented it to the benchers, who rejected it before they got to the Discipline Committee. And that was their reason for not providing the written reasons, because it didn't go to the next level, because they denied it going to the next level. I requested written reasons how the Law Society was complying with their statutory duty to protect the public, but I've received no response. There is a substantive and procedural problem here, that there is zero protection of my Charter rights. If court is not going to answer a constitutional question, not going to accept the transcript of trial as being the best evidence that I can provide, and can accept a woman's voice, then I don't have any rights whatsoever in this tribunal. And as you know, I attempted to get lawyers to represent me, and some of the responses were, "I have no experience with the matter, good luck." Or one defense lawyer said, "I will not represent you now or ever." The CRA seized both my personal and business bank accounts. When I reported the problem of the Minister of Justice not complying with the Charter to the RCMP National Division headquarters, who's mandated to investigate MPs, they responded to me, "We will not investigate, we will destroy evidence." The FMEP removed both my driver's license and my passport. When my ex took the matter to court, the judge made the payment retroactive for 12 months, so I was immediately $10,000 or $20,000 overdue. So my driver's license and passport were removed because there was over $2,000 debt. I had no bank account, I had no nothing. I couldn't even get to court or to any work for a year and a half. Last time I did ask you to help me get my passport returned. And I'm going to ask you again, Justice. My father is 87 years old. I don't know how long he's got to live. He lives in Australia. He's no longer safe to travel. I want to have my passport back so I can go see my father. I have forwarded the problem on to the passport office 2 years ago. I wrote to them detailing the problem of judges claiming that they can ignore the transcript of trial. I have never received a response to that letter. It is simply wrong to extort me and using my aging father as a tool of leverage. I did mention concern about prosecutorial abuse of discretion. When the BC Law Society is refusing to discipline lawyers, and the Attorney General of BC and Canada know about the Minister of Justice refusing to respond to the enforcement procedure of the Charter and have produced no argument. The purpose behind the prosecution is compromised because of the abuse of process of the Crown. Combine that with the unresolved request before the BC Supreme Court for a writ of mandamus means that the constitutionality of the court has not been checked legitimately by Parliament, and the court. Active steps of the court and Parliament have taken to attempt to deny that process is an abuse of process. We have a constitutional crisis here, along with denial, with no argument, and pretending we can just ignore it and everything will be fine. I'm going to refer you to Roncarelli versus Duplessis, which I believe has a lot of similarities to this problem. I'm not going to comply with their requests when the Attorney General is not complying with the Charter. Court responds, have you been back to the Supreme Court to challenge that order? My comment, why would I put myself into that system of abuse? I'm only here because if I'm not here, a warrant will be brought for my arrest. I'm not voluntarily going to Kelowna to be abused. And I've made that point to the Minister of Justice, and he is very well aware of that fact and the reasons why I've not received a response back. How can I safely go back and have my children abused in that court? I will not do it. When I was in court back in 2005, I was a father figure to a child from the age of 2 to the age of 10, when that mother decided that she wanted to take everything that she could possibly steal from me. I never saw the child again. I was broke and completely mentally devastated. I was essentially incapacitated for any function for 4 or 5 years due to PTSD. I could barely change sheets at the motel where I work. I'm going to read in some comments from some court cases. Landerville. Hearsay evidence of what one has heard rather than what one knows from first-hand evidence to be true is generally inadmissible in civil proceedings on the basis that its probative value is limited. There are a number of exceptions to the hearsay rule, and one of these exceptions permit the introduction of such evidence, but not for the purpose of establishing the truth of that evidence, but for establishing the hearer's state of mind. And my comment is, the question remains when Judge Shaw asked my ex-wife, the plaintiff, for hearsay evidence to counter my evidence, the transcript. What did he establish about her state of mind? That she would lie no matter what the evidence was against her? The problem is we also learned a great deal about the judge's mind, that he even asked the question. A judge using hearsay evidence against the transcript to protect a lawyer committing fraud and using that hearsay evidence for the purposes of establishing truth is, of course, appalling. I go on, I will comply if the Crown complies, but the Crown is not complying. The court says, it doesn't work that way. I respond, it does work that way. The court, you've made multiple arguments and allegations, but provided no evidence, sir, that your charter rights have been violated. I appreciate that you believe that, sir. I'm convinced that you sincerely believe that, but, sir, we're dealing with a very narrow issue here. But you've said that you don't trust lawyers because the Law Society didn't adequately investigate fraud on a trust account. You don't trust the justice system, you don't trust FMEP, you don't trust current counsel, and you don't trust lawyers. You've appealed to Parliament and the Prime Minister's office and multiple ministers and got no satisfaction in any of those places. My response, I have not received an answer. Not an answer, not a response, and there is a duty that they have to respond. Crown has a duty to respond first. If you think that I'm going to trust my children, my finances, my life to judges that cannot determine right and wrong between the transcript about what they say a court order should be and a lawyer's claim that the court order should be this, and their decision is to call the plaintiff and ask her what she has to say about it, yes, I don't trust the system. You're right, but I am trying to work with it. I am trying to resolve the issue. I did try to mediate with the lawyers. I did try to get a lawyer to represent the argument. I am still here willing to do that, but I'm not going to be abused. I want my fairness. I want impartiality, and it is my right. I don't know how to resolve it either, and the Minister of Justice is the proper person to do so. The court responds back to me, not today, Mr. Holsworth. Today it's me. I respond, sure, today it's you. And the court goes, and I have a request by the ministry to incarcerate you. And my response is, that's why I asked you to recuse yourself, because you cannot do your job today correctly. The Judicial Council is saying you have the right to ignore everything. And that's what the court system has done with me, is that they've ignored everything that I've said, all my evidence, and there is no way that you can claim that you can give me a fair and impartial trial based on the evidence before you. But I'm still here trying to work with you. I'm not disappearing off into the wilderness, which is what many people have said for me to do is, you should just leave. Abandon your children. I'm going to read from a couple of court cases here. Roncarelli and Duplessis. All official acts must be authorized by law. My point is, you don't have legal authorization because you're in conflict with the Charter. In order to resolve a breach in the Charter, it requires the repair of the breach. You cannot continue breaching the Charter and enforcing the law. I also comment from reference read provincial judges. This is the one about the judges not having their wages reduced. The quote is, the exercise of all public power must find its ultimate source in a legal rule. It must be procedurally correct and substantively correct. I don't think you can say that we're following fundamental tenets of justice here. This is some quotes from Nate versus the Attorney General, also BCGEU and Reclamation Systems. Citizens require unimpeded and uninhibited access to the court. And I would also say that should apply to access to Parliament. I should be given unimpeded and uninhibited access to the court. I don't have that. Relevant quote from Chief Justice McLaughlin, former Chief Justice of the Supreme Court. We expect our administrative tribunals to be bound by the law, to render decisions in an equal and predictive way, and to act in accordance with law and social values, justified to citizens in rationality and fairness. The ability to call for such justification as a precondition to the legitimate exercise of public power is regarded by citizens as their right. Every person dealing with the state is to be treated fairly and with respect. In the Manitoba language rights case, comment is, the vexing question, however, is what will be the legal situation for the duration of this period. All of the rights, obligations, and other effects open to challenge, since the laws under which they purportedly arise are invalid and of no force or effect. Invalid and a therefore ineffectual legal system. And I'll leave you with one more from Dicey. Every official, from the Prime Minister down to a constable or a collector of taxes, is under the same responsibility for every act done without legal justification as any other citizen. Officials have been brought before courts and made, in their personal capacity, liable for punishment and damages for acts done in their official capacity but in excess of their lawful authority. Frequent use of unbridled judicial power contains the seeds of its own destruction because it will erode the perceived legitimacy of the judiciary. My comment is, I very much admire the legal system. I want it to work. It's not working. I'm here trying to fix it. They go on, and I comment, you're threatening me with jail? The court says, I'm not threatening you with jail, sir. I'm promising you. I'm sentencing you to jail if you don't comply with my order. And I comment back, and you're refusing all my charter rights? The court says, I'm refusing all your charter arguments, sir. That, from my perspective, look like they're Swiss cheese. They are full of incredibly large holes, sir. My response, then tell me the argument against them, because I've not heard a single one. Why isn't there a constitutional question answered? The court, the only issue before me today is whether you could and did comply with the financial disclosure, and you raised many charter arguments that you've raised in every legal proceeding that you claim to respect, sir. But you're the one who's breaking it. You're breaking the justice system, sir, by taking up multiple court days to make the same arguments over and over again that nobody gives any credence to. You believe them. I accept that, sir, but you're not complying with court orders. My response, you're obviously biased. The court goes back to me, sir, because I don't accept your argument doesn't make me biased. It means I don't accept your argument. My response, for sure. But then why is there not a response to the constitutional question that's being presented? And they kind of left it there and promised me the 2 weeks of jail, but we've got to resolve that. Thank you for listening.